Good afternoon, and thank you for being with us here today. It's about 2 o'clock on October the 5th, 2001, and we're here to discuss the 2021 Marijuana Bill and Technical Package. Thank you for taking the time out of your schedule to attend. My name is Amanda Borup. I'm a policy analyst for the Oregon Liquor and Cannabis Commission. So just a few housekeeping items before we get started. Today's meeting is being recorded. If you've called in or if you're on the computer, please be aware to be muted when you're not speaking. I'll also be acting as tech support today. Periodically, I will mute all if I need to make sure that there's not a lot of background noise. If I do that, please don't take it personally. And everybody, like I said before, is asked to remain on mute until the introduction portion of the meeting. Only invited committee members will be part of today's conversation. Members were selected due to their level of interest or position within the community. If you are not an invited member or proxy, please use the call-in number that was transmitted on the notice for this advisory committee. If you are an invited committee member and you're dialing in on the phone and you need the link to the meeting, please send an email to olcc.rulemaking@oregon.gov and we can provide you with the PIN number. For committee members, there is no raise hand function in GoToMeeting, and so we will work to facilitate this meeting in such a way that all committee members are able to participate. That being said, please be courteous to other committee members so that we don't have multiple participants speaking at once. With that in mind, we ask that each of you serve as a goodwill ambassador to the discussion today, and you may represent your constituency professionally. Non-committee members will be able to send comments during the public hearing and during the public comment period, which will follow later this year. Committee members, please state your first and last name for the record prior to making a comment. And in the hopes of cultivating a platform for better communication, we will not be doing a share screen during these rules discussion. That being said, please make sure you have a copy of the draft rules in front of you. And somebody from OLCC in the chat will put in a link to our public meetings page, which has the draft rules if you need them. All right, so now that that's taken care of, we can get started. Many of you are familiar with the rulemaking process, but those of you who have not yet had the opportunity, or for those listening in, I will begin by saying a few words about rulemaking and the purpose of the advisory committee meetings. The purpose of an advisory committee meeting is to increase the public's involvement in the drafting and development of their administrative rules. The Oregon Legislature, through its enactment of the Administrative Procedures Act, which is ORS Chapter 183, stresses the critical importance of the public's participation in policy development. Advisory committees are an excellent way to solicit input from internal and external stakeholders who are likely to be impacted by the development or an amendment of agency policy or rule. Consequently, advisory committee invitees may include licensees, permittees, industry representatives, OLCC staff, members of law enforcement, local government, the public, local community organizations, small businesses, and other interested stakeholders. The purposes of having all the members on the committee today is to hear from different parts of the industry, public health, and public safety partners. The Commission strives to hear from all interested parties. Our role today, we will explain the background of the context of these rules and the changes that are being proposed in the package. And we will provide facilitation to ensure that all committee members can provide input. During this afternoon's meeting, we will seek your input on the proposed amendments to the bill and technical package. In today's meeting, we'll be discussing proposed changes related to legislative changes and technical changes for our rules. In addition to this committee meeting, we'll have and host two other advisory committees. One was last week where we talked about artificially derived cannabinoids, and in a few weeks, we'll have another one where we talk about the violation reclassification. Under Oregon's public meeting law, the meeting is open to the public and members of the public are free to observe the discussions, but may not offer comments. The agency will digitally record the advisory meeting and will have it posted to our website probably next week. And so I would also encourage anybody who's interested to listen to the meeting from last week that has already been posted on the website. We understand there's a lot of discussion about this topic, but before we get into the actual package, does anybody have any questions about the Rules Advisory Committee procedure? All right, so I'm not seeing any questions, so I'm going to go ahead and start with introductions. I'm just going to go down a list the way that I see it on the side of mine, and I'll go ahead and call your first name. if you could go ahead and just introduce yourself and let us know who you're with, who you're representing. So the first person I have on the list is Alan Lewis.
Hi, Alan Lewis, Natural Grocers. We're actually not a retailer of THC products, but I was invited to participate, and we just want to match things up to what's going to happen in hemp. Thank you.
Great, thank you. Amanda Metzler.
Amanda Metzler, founder and president of Farms Inc.
Thanks. Amanda Seibert.
Hi, I'm Amanda Siebert, and I am owner and operator of Synergy Skinworks.
Thanks. Anthony.
Hi, Anthony Galtoski, OLCC Policy Analyst.
Ben. Ben, if you're trying to introduce yourself, you may still be on mute.
Sorry about that. Yes, this is Ben McInnes, and I'm representing Consumers and Patients of Oregon.
Great, thanks. Casey?
Thank you, Amanda. Casey Woodland here, the Executive Director of the Oregon Retailers of Cannabis Association.
Thank you. Courtney?
Hi, everybody. This is Courtney Moran. I'm the president and lobbyist for the Oregon Industrial Hemp Farmers Association, and I'm also serving as proxy today for Ann Johnson with PacWest Lobby Group.
Thank you. Dave?
Hi, everybody. This is Dave Fugie with Rip City Delivery. Thank you for having me on the call.
Thanks. David? David with OLCC.
Hi, I'm David Standiford with OLCC.
Gabe?
Hi, Gabe Parton Lee, General Counsel over at Wild and Wild CBD.
Okay. Gary?
I'm Gary Wright, the Marijuana Compliance Technician.
Thanks. Jason?
Good afternoon, everybody. Jason Hanson, Director of Compliance with OLCC.
Jess?
Hi there, Jess Nyworth, the Public Health Policy Analyst with OLCC.
Thanks. Kelly?
Good afternoon. This is Kelly Rout, Director of the Administrative Hearings Division with OLCC.
Thank you. Leslie?
Hi, guys. My name's Leslie Gonzaga, and I'm the Operations Manager for the Dub Wholesale.
Thank you. Lyle?
Hi. Lyle couldn't be here at the moment, but I am his business partner, and we are both license holders for Cannaband, a retail facility in Bend, and also Northwest Soil Tech, a production facility.
Okay, thank you. Mary? Mary, if you're trying to introduce yourself, you may still be on mute.
I'm sorry about that. Mary Wolf from Lori and Mary Jane Edibles.
Great, thank you. Mia?
Hi, Mia Getlin, partner at Gleam Law.
Thanks. Patrick?
Hi, I'm Patrick Owen. I'm the Recreational Marijuana Program Manager, Recreational Marijuana Licensing Manager with OLCC.
Thank you. Rich?
I'm Rich Evans with OLCC.
Thanks. Rob?
Rob Bovett, Legal Counsel Association of Oregon Counties.
Thank you. Scott?
Hi, this is Scott Pazetsky. I was recently the compliance officer for Drops. I'm an attorney in Portland.
Thanks. Shane?
Hi, I'm Shane. I'm with Medicine Farm Botanicals.
Thank you. Stefan? I might have mispronounced your name, but I thought it was possibly Stefan. You might still be on mute if you're trying to introduce yourself. Okay, we can come back to. Steve Marks?
Steve Marks.
Great, thanks, Steve. Stephen Crowley?
Stephen Crowley, OLCC, Hemp and Processing Specialist.
Thanks. Sunny Hart?
Sunny Hart, they, them pronouns with Green Hornets Wholesale.
Yeah, thank you. And then Sunny Summers?
Good afternoon. I'm Sunny Summers. I'm the Cannabis Policy Coordinator for the Oregon Department of Ag.
Thanks. And TJ?
Hello, TJ Sheehy, Director of Analytics and Research with OLCC.
Great, thank you. So I made it through the list. If anybody had joined since we started introductions and you didn't have a chance to introduce yourself, feel free to go ahead and come off mute, and you could do that now.
Good afternoon. My name is Stefan Massey, and I'm the Compliance Manager at the CDC Dispensary in Tigard.
Great, thank you. All right, with introductions done, we can go ahead and get started. So what we've done today, we're going to kind of look at this rather than going through everything line by line. We're going to kind of look at it in like subject matter areas. So I'm going to go over basically things from Senate Bill 408 that are not part of the violation reclassification, and then also things from House Bill 2519. And so Senate Bill 408 gave licensees, especially producer licensees, more allowance to transfer to similar owned businesses. And then 2519 was about the out of jurisdiction delivery. So I'm going to go ahead and start with those. And what I'll do so you guys can follow along easier, because when I was making my notes this morning, I realized we don't have page numbers, so that's not going to be helpful. But I'll go ahead and just talk about the rule number that I'm talking about when we start to kind of discuss these changes. So, like I said, Senate Bill 408 allows producers to receive from to send product to a processor, and then they can receive concentrates and extracts back and products back from the processor if those processors only used material from the producer. They also allow a producer to transfer to a different producer when they have similar ownership. And so we had to go ahead and update rules around, first of all, common ownership. So the common ownership rule is actually in the definitions section. And so that's 845-025-1015. And common ownership is number 19. And so what this does is it reflects the statute, we hope, for the new definition of common ownership. When the industry drafted this bill, they also changed the common ownership definition for retailers as well, because retailers have been allowed to transfer to other retailers with common ownership. Basically what this does is it gives producers and retailers that same definition. All right, and then if anybody has, any comments or wants to talk about anything, feel free. But we're trying to stick as close to statute on this so that, people can get those privileges like they want. The next change is going to be in 845-025-13300, and that's the trade sample rule. And so it basically just adds those concentrates, extracts, and products into the trade samples that producers are able to give other licensees. And since they're allowed to have them now and get them back from processors, they can use those as trade samples. All right, so the bulk of the changes for this section are going to be under the producer privileges. So that's 845-025-2020. So if people want to take a moment to take a look at this, what it's doing, first of all, is adding in the common ownership definition so that you can see that this producer to producer transfers under common ownership. And then it gives them the transfer privileges and then also the receiving privileges. The one thing that's not about the producer to producer transfer, but it's also from 408, allows the producers to receive up to 200 marijuana seeds in total per month from any source within the state of Oregon other than a licensee, laboratory, or research certificate. Producers can already get seeds from those, so this is just opening it up to the statutory definition of that they're able to get those extra 200 seeds. Okay. So any questions on this section? You guys want a second to look at it? Just give it a minute.
Hi.
Hi.
Hi. I'm just looking at the page where it references the 200 marijuana seeds total per month. In the same section, it also talks about, or it's close in here, also talks about, I think it's the addition of keef.
Yes. So for about the past couple years, producer licensees have been able to have and produce keef.
But we're not able to produce ice hash. That's like a limit, a big limit on the producer end, being able to work with keef, but essentially not being able to work with ice hash. Is that
correct? Yeah. So it was a statutory change. Actually, Stephen, did you want to go?
Yeah, I was just going to ask, could you state your name for the record, please?
I'm sorry, what was that?
Could you state your name for the record?
Yes, Lizette. Lizeette. Same
Great.
last name.
Yep. Thank you. That's wonderful. Yeah. So it was a legislative change a couple years ago. What originally keef was considered a concentrate or an extract. But as everybody is well aware, when you're a producer and you're harvesting marijuana and you're trimming marijuana, you actually do just naturally come up with a lot of keef. And so the legislators changed that just to make it an allowance so that producers weren't breaking the law every time they had a harvest. And so they went as far in legislation to make it keef, but at this time it's not ice hash. However, there is a micro-tier producer license that allows you to be able to make limited concentrates.
Okay. Thank you.
Yes.
Steve Crowley, OLCC. Also, just to clarify, the language around keef there is bolded. It is just moving up language from further down and then adding the ability to transfer it to license it, producers under common ownership and then keeping the ability to transfer it to other licenses. It's part of the reason that the entire language moved is just to make the order of privileges here kind of flow more naturally.
Amanda Metzler, Farms Inc. Amanda, just a clarification question. This, because it does say sell, transfer, or receive, that it allows the farmer to do direct sales once they receive their extract back to package and be able to sell those either to a wholesaler or directly to a dispensary.
Yep, and we'll get into that later in the other privileges where it talks about it. And I have it in my notes to flag it, but I'll do it now. We actually forgot to allow retailers to receive it from producers in this draft, but we will be adding that in. That was just an oversight on our part.
Okay, got it. Thank you.
Yeah, it always seems easy when you're going through this. You're like, done. And then when you read it, you realize not quite yet. Okay, so any other questions on the producer privileges section? All right, so the next section is actually the retail. So it's 845-025-2800. So one of the big changes here is it does allow marijuana retailer to sell seeds to a producer. The reason we put that in is because now people can get 200 seeds from anywhere. and they can get seeds from other licensees, so they might as well be able to get seeds from retailers too. It just made sense to us. Like I said just a few minutes ago, we're going to add in the allowance for a retailer to receive concentrates and extracts from a producer who received them from a processor. That same language. Also changes the definition of the common ownership for a retailer to transfer to a retailer, so it matches the same definition as the producer and the new statutory definition. Looks like I have somebody just come off of mute. Mitra, did you have something you wanted to say? Oh, no, back on mute. All right. So any...
Hey, Mary from Lori Mary Jane.
Yes.
I had a question, because it looks like it's expanding the, or increasing the amount of usable marijuana from 1 ounces to 2 ounces that retailers can sell. So I'm wondering, is that to do, well, anyway, I'm wondering if with the change, the increase of 100 milligram edibles coming up, if there's an opportunity to increase or change the limitations on cannabinoid products.
And we'll actually be discussing the concentration limits. It's going to be a little bit later in the schedule today. So if you don't mind, if we can hold off until we get to the concentration limit section, we can discuss it then.
Okay, just specifically on kind of what retailers are allowed to sell to customers in terms of like maximum per day.
Stephen Crowley, OLCC. So the limits for cannabinoid product in solid form and cannabinoid product in liquid form, those are the personal possession limits that are in statute. So we can't really increase it beyond that without having retailers sell an amount that the consumer can't legally possess. The increase from 1 to 2 ounces was going along with the increase in the personal possession limits for usable marijuana.
Okay, understood. So there's just no possibility to change that at this point?
Correct.
Okay, all right, thank you.
And so, yeah, you did, I'm glad you brought that up though. So we did, Senate Bill 408 did allow for people on their person in public to be able to have 2 ounces of usable marijuana. So in this draft, we have that listed as 2 ounces rather than the 1. We always had it 1 ounce just because that's how much you're allowed to have on your person in public. Now, well, come January, you'll be allowed to have 2. So we're recommending that change as well. All right, so then the next section directly related to 408 is the processor privileges. 845-025-3215. This is the allowance for the processors to be able to transfer back to the producers that they had processed for. And then there's also a section in here that talks about artificially derived cannabinoids. That was discussed in length last week at the RAC about artificially derived cannabinoids. And then we will discuss it briefly this afternoon as well, just based on the feedback that the agencies received since last week. All right, the next section is going to be the wholesale section. So that's 845-025-3500. And I believe this one we may need to make some updates to reflect the new producer privileges as well. All right. No comments. The last part about this, we're going to flip way to the back here, is transportation. It's 845-025-7700. So there's two things here I wanted to call out. The first one is a change that's not something that was a result of 408 or 2519. Basically, we have a lot of licensees who have a hemp business and a marijuana business, same people, they're under common ownership. It's just one of them has a hemp certificate and one of them, or they have a hemp certificate and one of them have an OLCC marijuana license. And so a lot of people had been wanting to transport in the same vehicle. Since everything's in metric, they could keep it separate, have manifests for everything. Unfortunately, the way our rules were before, it really wasn't an option, but we definitely see why people don't want to be making multiple trips, and that is somewhat of a safety issue in itself. So this change would just allow licensees that have that common ownership situation to be able to make one trip rather than two. And then the second change here is the removal of the route information from the manifest. So prior to Senate Bill 408, you had to have in your manifest like kind of a turn by turn on where you were going. You actually are not going to have to do that anymore in the future. And so that was removed from the language. And so that goes through a majority of the changes from Senate Bill 408 as it relates to things that are not violation. Senator, does anybody have any questions about what we just went over? And if not, we'll go ahead and move into 2519.
Hi, Leslie Gonzaga here. So if we no longer have to do the route turn by turn, is it just supposed to be like the Google directions then from, let's say, the Dub to said dispensary?
So since it's like the written description has been removed, it's going to be everything listed here rather than like the turn by turn. And so TJ, I see TJ's on the line. He may give a little bit more, have a little bit more of an idea of like how the manifests actually work than I do.
Okay.
Yeah, I can weigh in here. It's TJ Sheehy with OLCC for the record. So there's not going to be a change in metric. So you would still have to put some sort of text in the planned route just so that metric will allow you to create the manifest. But unless you're doing an overnight stop, there isn't any specific requirement and rule of what you would have to put, because the originating address is your facility or the wherever it's coming from. The destination is already put in when you put in the sending license. The car and driver information is put in separate from the route. So metric would require you to put something in the route, but it could just be placeholder text of, from X location to Y location or something like that. If you do have an overnight stop involved, then you do have to still put that information in the route because that was retained by 408, that you still have to specify any overnight stops and where you're going to be.
Awesome. Thank you.
And what would be required on a circular manifest?
TJ Sheehy with OLCC again. The circular manifest requirements are unchanged in this. So that language is still in here. And so you'd still have to specify the intermediary stops and follow the same procedure as you do now. You just wouldn't have to put anything really, if you were doing the intermediary stops, you just list the intermediary stops. You wouldn't have to specify the directions to get from intermediary stop 1 to intermediary stop 2.
Okay, any other questions?
Amanda Metzler.
I have a question around the manifest, and if we're doing, for example, what was just mentioned around working with hemp, like the ODA side of hemp, and making deliveries throughout the state for hemp, and then we're also have our OLCC metric transfer with the directions and the part of the manifest with the directions. How would we go about including any of those kind of intermediary stops?
So I may not have been clear enough when I was talking about the transporting at the same time. So it would be for somebody that has an OLCC hemp certificate and an OLCC license. So I hope that was clear. So it's not just, and so everything would be in metric. And so you would have your separate manifests, I believe, your hemp items and your marijuana items.
I see. So only for the OLCC licensees that are working in the hemp side, not related to like beyond the OLCC for hemp transferring.
Correct. Correct. This is for people that have an OLCC license that also have a hemp certificate that have things entered in metric.
Great. And so, for example, our license, we have licenses on both sides. But for example, we sell some of our hemp through OLCC dispensaries, and then we also sell through like other retailers in Oregon. And so I'm curious, will those kinds of mixed transportation be allowed in the future, or still not allowed?
No, still not allowed. It would be things that are in the metric system that you have a manifest for. So if you were selling outside of the metric system, like to that would, you wouldn't have a, well, I don't know. It's a good question, actually. And Stephen might pop up with a little bit more information.
Yeah, Stephen Crowley, OLCC. So these proposed changes don't impact that scenario. We can connect later about how things operate under the current rules.
Amanda Metzler, Farms Inc. TJ, I had a question. So when the transfer manifest is getting created, since something has to be put in there, is there going to be a better educational bulletin that goes out explaining it? Or could there be a little line item above that that says, you know, I just think there's going to be a little bit of confusion on not having to enter turn by turn, but that something has to be in there to move forward.
Yeah, Amanda, I can answer that. So unless TJ wants to, but just generally speaking, everything.
Yeah, I'll jump in, TJ with OLCC. So, you know, right now I'll have to look into it. It might be that we end up creating different transfer types like overnight stop, circular manifest, not overnight stop or something like that. We might be, I'd have to double check. We might be able to turn off the requirement for routes. I'm not 100% sure. If we're not able to, then I think, yes, we would include that in a bulletin when we when we pass these rules, talking about what you would be expected to put in the route. We'd add it to the metric wiki, those sorts of things.
TJ, I think it's a fantastic idea for 3 different types of options that you could choose if that turns out to be something that's possible.
Great, thank you. Yeah, and just I'm glad you said that, Amanda, because I would highlight that every year so far, every year when we've had these big rule changes come out in December and be effective in January, we do a pretty comprehensive bulletin going over the changes and adding in the FAQs. So we plan to do that again for this. And Mia, I don't know if you had a question. Yeah.
Yeah, so for the language in multiple places about producers being able to get back products made from their marijuana, I think the language is a little narrow, saying made using only marijuana produced by the producer. I mean, technically, I read that as excluding other non-cannabis ingredients, which I know isn't the intent. I'm wondering if we can narrow that down to make it clear that what we're saying is that the only cannabis ingredients can be marijuana produced by the producer, as opposed to made only using only marijuana produced by the producer. Does that make sense?
Yeah, it definitely makes sense. Yeah, I get where you're going with that.
TJ with OLCC again. Sorry, Amanda. I just did a really quick double check. It looks like we can't turn off the route. You know, we can do things like require or not require an origin or a destination for external transfers as an example, but we can't turn the route on or off. That doesn't mean we can't necessarily create different manifest types, but that might actually introduce more confusion rather than less by still requiring a route, even with those different things. So we'll explore that though. I think, you know, at minimum, we include it in the bulletin. And then also when we do our metric audits, that's when we have eyes on the route and can provide education through that way too. If people are, you know, putting more information than they need or not enough. we can educate that way too.
Thanks, TJ. All right, anything else about this section? And then we're going to move on to delivery. Okay, seeing nothing, I'm going to go ahead and move on to delivery. So basically, House Bill 2519 allows retailers to deliver to adjacent cities and counties if the city and county has passed an ordinance opting in and then provided that ordinance to the OLCC. So a couple of things I want to mention about this first. We've been getting a lot of questions about it. This part of the law also does not go into effect until January 1st. So, we have to go through the rulemaking, and cities and counties will be able to opt in after that date. OLCC plans to work with the League of Oregon Cities, Association of Oregon Counties, to get some information out to their members so cities and counties are aware of this change. Right now, basically, and I'm sure everybody knows this, retailers can only deliver in the jurisdiction that they're licensed. Unless it's to a medical marijuana patient, retailers can deliver statewide to medical marijuana patients. And so there's a few changes here that were in the law. So basically, the delivery driver is going to have to be able to communicate with the retailer while they're making deliveries. The delivery vehicle has to have a GPS. Part of it says that the delivery vehicle may not have any markings or signage that indicate that it's transporting marijuana, which is a big change from what we have right now. And then it changes the transportation limit of product from $3,000 in retail price to $10,000. So I kind of wanted to go over just these changes really quick. And then there's two things that I would like us to talk about a little, I'd like to focus on a little bit in the conversation. So the first part of this comes in the delivery section, which is 845-025-2880. And so that's where we make the changes to the $10,000, make the requirement that they have to be able to communicate with the retailer, and then it has the GPS. The next part of that rule, if you keep going through it, it basically gives the allowance for the person to deliver to a city or unincorporated county that has provided us with an ordinance that they're okay with getting deliveries. And then that's also where the markings, no markings, come in. And so those are kind of the two things I wanted to talk about. So the statute, House Bill 2519, uses the term adjacent for cities and counties that retailers are allowed to license. And so what we've kind of been struggling with is a way to make that really easy, first of all, for cities and counties to understand, make it easy for our licensees to understand, and then also make it easy for the general public to understand when they're trying to get deliveries. We do plan on having a map where we'll map out, opt-in cities and counties for outside of jurisdiction delivery, which should help. But I think the question the question I'd like to pose kind of is the term adjacent. For example, let's say that, and this is just an example, I don't even know if they allow for retail, but let's say you're an unincorporated Polk County and you have a retail license. Does that mean that you can deliver to all adjacent counties or all adjacent cities and counties? Or then if you have a license, let's say in Monmouth, which is in Polk County, does that mean you can only deliver to touching cities, or can you also deliver to the unincorporated county where you're located? So I kind of wanted just to get your thoughts, if anybody has any, on the term adjacent and how we can make that work in the easiest possible way.
So this is Rob from AOC. Can I chime in here real quick?
Yes, please.
I would say the answer to your questions, Amanda, is all of the above, because I think they're all adjacent. But I did forward on some additional language for you to consider, or maybe the RAC to consider. But the way that Big C is written now doesn't read quite right. So the way it reads now is a city or unincorporated county that has provided OLCC with an ordinance allowing for interjurisdictional deliveries from adjacent cities or unincorporated counties. First, I don't think that language addresses your questions. And second, there is no really such thing as an unincorporated county. So here's what I propose as language that I think resolves your questions in the affirmative and has language that I think would help cities and counties better understand what's going on here. And so here's what I have crafted. So with the lead in, it would say a retailer may deliver marijuana items only to a location within A, B, and then adding a new C, a city or unincorporated area of a county that is adjacent to the city or unincorporated area of a county in which the licensee is licensed, if the adjacent city or county has enacted an ordinance allowing for interjurisdictional deliveries from adjacent cities and counties. And I think in that way we answer all of your questions, yes, and we have language that is actually meaningful to city attorneys and county attorneys. So that'd be my suggestion. So for example, in your hypothetical, I think that the licensed shop in unincorporated Polk County should be able to deliver to Marion County, assuming Marion County allows that, should be able to deliver to any of the cities inside Polk counties to the extent that those cities opt in. And that a city, just pulling something randomly out, Salem, which is where I live, if you had a retail shop there and the city of Kaiser said, yeah, you can deliver there, you could go there. If you had Marion County saying, okay, you could deliver there. So I think the answer should be yes to all your questions. That's my take.
That's awesome, Rob. Thank you. And really, thank you for that. That's a great catch that we screwed up our language on that.
Rob, this is TJ with OLCC. Just a follow-up question. One scenario I don't know that I heard you say, and I just want to get you to weigh in on it, is if you're in an incorporated city in Polk, should you be able to deliver to an incorporated city in a neighboring county, even if it's not directly touching either the city or county that you're licensed in?
TJ, it's a great question, but Scott and I, who worked on this language in the bill, as you're aware, weren't thinking that that would be allowable at this point. So that would be the idea being that you're essentially crossing only one city or county boundary. In your scenario, you would be crossing, sounds like 2 or 3 maybe. And so, I mean, we could pursue that in different legislation. I certainly would help with that, but I don't think that encapsulates the word adjacent.
That's very helpful. Appreciate it. Does anybody else have any thoughts on adjacent?
I sure do. Stephen Massey, the CDC dispensary. We are in unincorporated Washington County, and adjacent to my understanding of the language would be Beaverton, Tigard, potentially Sherwood, and Southwest Portland. So that would, given the nature of crossing additional boundaries, Hillsborough, would that be off of our potential delivery zone? It is in Washington County. We're in unincorporated Washington County. Hillsborough is not adjacent to any portion of unincorporated Washington County as far as I know. So that it's just up there for a consideration is in that milieu that you're discussing here.
Patrick Owen, OLCC marijuana licensing manager. I mean, Hillsborough is, as I understand it, entirely contained within Washington County. I think by definition, it therefore must be adjacent. You raise an interesting question regarding Portland, the city of Portland, which borders Washington County, but then you've got the separate border of Multnomah as well. When you cross into Portland, are you crossing 2 borders or 1 border, and is Portland adjacent? I think is a question worth answering.
Yeah, and for us, I mean, just logistical reasons, we would clearly want to stay in this side of Washington County, but for others who might be closer to Multnomah, that may be relevant to them.
It's very helpful. Thank you.
So this is Rob from AOC again. I certainly have my answers to those questions, but I don't know if people are interested in them.
No, go ahead, Rob.
Well, under the first hypothetical, I think there are areas of Hillsborough that are up against unincorporated Washington County, so my answer would be yes. If it turned out that Hillsborough somehow was in a corner of Washington County and wasn't adjacent to unincorporated Washington County at all, anywhere, which I find hard to believe, then I think adjacent wouldn't work. I think crossing over into an additional county, it doesn't change anything, because once you're in the city of Portland, you're in the city of Portland, and I think the whole city of Portland's opened up. I could give you an even more extraneous example. Let's take Wilsonville. Wilsonville is an incorporated city, and it actually lies in two counties, Clackamas and Washington. Let's say we had a retailer in the unincorporated areas of Clackamas, somewhere in, I don't know, I'm just making something up, somewhere in the middle of rural, wherever, between Oregon City and Canby or something like that. They could deliver into city of Wilsonville, and I believe they could also go into the north part of the city of Wilsonville, because they're still within the city that is adjacent. So I think that key word adjacent is what you ought to focus on. If we want to change it in future sessions, like I said before, because we want to allow for even more diverse competition in a broader geography, I think we can do that. But I think we decidedly chose the word adjacent for now.
Great, thank you. The next part of this that I wanted to discuss briefly before we move on to the rest of the agenda, because we do have a lot of things to discuss today. Part of 2519 says that the delivery vehicle may not have any markings or signage to indicate that the vehicle is transporting marijuana. So the question there is, like, right now we allow delivery within jurisdiction and we don't have any rules about markings on the cars. So, but now the statute changes that. And so we just kind of wanted to get, some thoughts on that. Just, kind of just open it up for a little bit discussion, because we do have to follow what the statute says. So that would be a pretty big change. I guess the question would be, what indicates somebody is transferring marijuana, right, or delivering marijuana? Would just having your trade name, that wouldn't really say you had marijuana in the car, right? It could.
Yeah, that's what I was going to say, is just kind of what's the difference of it. Who's to say I want to put, my name on a delivery vehicle that's delivering boxes for advertising versus, somebody that's going to put it on that's actually delivering marijuana? What would be the determining factor?
Yeah, thank you. And Amanda, would you mind saying your name for the record?
Sorry, Amanda Sieber with Synergy Skinworks.
Awesome, thank you.
Casey Houlihan here with Orca as well. And I know that this is something we've heard about from a lot of our retailers as well, that they would like to be able to continue having vehicles that do advertise, at least the trade name of their business, so people are aware when it is turning up that that's the delivery that they're looking for. And then obviously also for the crossover advertising opportunities. So if there is a way to work that into statute to allow the business to declare themselves without necessarily, making it clear to the broader public that there is cannabis in the vehicle, then I think that would probably be a needle worth threading for many.
Yeah, so I'm just going to go ahead and put it out there. If anybody has any ideas about language that would still meet the statutory definition, but then also be able, like you said, it's kind of like, excuse me, and we discussed this too. It's a little bit, if I'm going to order marijuana delivery, I kind of would like it to come in a vehicle where I know that that's what I ordered. That could be just me though. So any ideas on language, you can send to the olcc.rulemaking at oregon.gov, and we'll definitely look at those and take them into thought when we're trying to draft this. All right, so that's the changes that I had for 408 and 2519. And Stephen Crowley is going to talk about some different changes to the rules up next. So thank you.
Amanda, one thing before you move on, Amanda Metzler, Farms Inc. When we were in the wholesaler privileges, you said that you might need to update that for producer, and I did notice it, so I just wanted to make sure that number one, big letter C, is going to be able to add the processed information, the processed material as well.
Yep, it totally will. I honestly didn't realize until this morning that we hadn't put it in there.
Okay, great. Thank you.
Yep. So Steve, you ready?
Yeah, Steve Crowley, OLCC. So another piece that we're implementing, House Bill 3000 added the ability for processors to transfer hemp products to unlicensed locations, basically opening the door for hemp products to flow out of the OLCC system. So there's a little bit of language in 845.025, 3215, the processor privileges, basically just saying that they can transfer hemp items to a person that's not a processor, retailer, or wholesaler as allowed under 845.025, 3320. And then the next rule there is 3320, which is a new rule for hemp item transfers to unlicensed persons. Basically, the item needs to be hemp. It can't contain any marijuana. There's still no path for marijuana to exit the license system at this point. It does need to comply with all the testing requirements that any other hemp item that a licensee that a processor has needs to comply with. And then it has to not exceed 0.3% total Delta 9 THC. The activity gets recorded in metric. Once the processor generates the manifest, then the hemp items that are being transferred out need to be held on site under camera coverage for 3 business days prior to removing them from the licensed premises. That's kind of the general idea. Any feedback on that rule?
Amanda Metzler, Farms Inc. Stephen, I have a question. So hemp items that are going to be leaving, are these hemp items that were actually produced by OLCC licensees and now they're moving them out of the system? Is that what I get to understand this?
I mean, it's pretty open-ended. It could be a processor has received a finished hemp good from somebody outside the OLCC system, somebody with a hemp certificate, and then wants to transfer that back out. Or it could be they received some hemp or hemp extract, processed it into, say, a hemp tincture, and then they want to transfer that out either to sell on the general market in Oregon or even for export out of the state.
Is Amanda Metzler again, sorry, Farms Inc. Is there a reason why we wanted the language to be so vague?
In what sense?
That you said that it was that this can be them anything if they bring in hemp that's processed not by an OLCC licensee into the OLCC system and then decide, oh, just kidding, we don't want it in the OLCC system anymore, and then they're moving it back out. I mean, that seems a waste of time. I don't think that really makes sense. Why would they be doing that? Why is that allowed?
Fairly OLCC. So, I mean, we have had some interest right now when a OLCC licensee receives a hemp product from a certificate holder, and then they ultimately find that they can't sell it or it's not quite what they were expecting. There's no mechanism for them to return that product to the origin point. So that is a legitimate need that we've heard about. Also, just if hemp products are being allowed to transfer out as long as they've been tested and they're under the 0.3% Delta 9 THC that is the national standard for hemp, we didn't see any clear reason to carve out that only certain types of hemp products or with certain unique histories to that item be able to be transferred out. The statute kind of implies that this is a general privilege of hemp items, and so that's how it's been written in this draft.
This is TJ with OLCC. I just want to clarify, Amanda, you asked even if it's produced by an OLCC licensee. I just want to clarify that if a OLCC producer grows a plant, it's marijuana. So this is only applicable to things that are from certified industrial hemp material, in other words, grown by a ODA hemp grower, and then come into our system as hemp. And then again, like Stephen said, leave as hemp, not being commingled with any amount of marijuana. So I just wanted to clarify, because you said the word produced, I just want to make sure that it can be manufactured by an OLCC licensed processor, But if it's grown in any way by an OLCC producer, it's automatically marijuana, regardless of the THC content.
Thank you for the clarification. I appreciate it.
Mitra Stickland with Ohm Extracts. In section 3C, it mentions about carrying a physical copy of the manifest during transportation. Stephen, you had just mentioned about export to other states, etc. And so I'm curious if that would mean the manifest would then be shipped with it, or how to kind of specify for export. And also one thing that we had brought up on the previous meeting is the opportunity for in other states where there are dispensaries that are working in the metric system as well, for our state to then be able to export hemp into another state's metric system directly with all of the test results attached, et cetera. Are there opportunities for that? I spoke with the folks at Franwell Metric and they said they don't see why not, but it hasn't been done before.
Steve Crowley, OLCC. Yeah, at this point, I'm not aware of any interstate connectivity of metric. I think that's something that would need to be thought through in some detail. So it's not something that I think is on the table right now. In terms of the manifest, I mean, that requirement is for the licensee, if the licensee or their representative is transporting it. If it's going to be picked up by somebody else, then the manifest requirement is not there.
Hi, this is Shane with Medicine Farm. I just had a question about transferring out hemp items again. So would there be a pre-approval process with label IDs for these types of products if they were still going out the door and being sold to non-dispensaries, for example? Or is there anything that has to happen for like packaging and labeling guidelines essentially for OLCC, or I guess metric hemp items to be leaving?
Steve Crowley, OLCC, no, there's no packaging and labeling requirements on here, since, I mean, those are something that vary a lot from state to state. We'll get to it later. If it is a hemp, industrial hemp derived vapor item, a hemp vapor product, there are some rules that are going in place around those if it's intended for sale to consumers in Oregon. But outside of that, no, there's no labeling requirements. You just, as a business, need to make sure that it's compliant with the labeling requirements for whatever market the product is destined for.
Okay, another question. You said there was a 3-day hold for products that would be leaving that system under camera, just like a normal waste, I suppose?
Right, 3 business days, so not including weekends or holidays.
Would there be a specific like icon and metric or anything to mark for, or I guess just like anything to note that, or language that would be needed to like make that note as a waste product or anything when you make an adjustment in metric?
This is TJ with OLCC. So the idea would be that it would be on an outgoing manifest 3 days in the future. So it would be on a manifest that has not left yet.
Okay, thank you so much.
Brent Kenyon here, Oregon Original. I just wanted to make a quick comment on the thought of out of state. So when working on this legislation, the plan was essentially Oregon will be the first hemp production state where we're making products that are actually run through a regulated testing system, which would be super attractive to other states' metrics potentially for the future, so we can get these products out. As most of you know right now, there's very little oversight over a lot of the hemp products that are in the market, almost none, in fact. So we really were excited about this because it gave us an opportunity to kind of lead the way nationally on what it looks like to have a regulated product that's still got some tracking methods behind it and also the testing piece. So everyone I've talked to in other states that are working on that type of thing are super excited about having this. So I was excited to see that we could make something like this happen, so we didn't have to obviously have separate facilities to create hemp products in if we want to be in the hemp business as well as the cannabis business. But so I think it's going to be great that we'll kind of set that tone. So I think what you'll see is other states following suit as they tighten up on their hemp products, because it's scary out there for people to order products right now. And it's still, I know we're working on D8 here, but that's not something that's being done around the country. There's a lot of places that are still shipping stuff out. I've had family members order things online that ended up having THC in them that have never, these people are 70 years old and never had THC. And they called me and it's like, well, what hemp product can I trust? And so we're actually have a great opportunity here where we'll be the only state in the union and the only products in the country that actually come out with a stamp of approval from a laboratory, and they'll know what they're getting. There's no BSing the levels, because a lot of times you could test what the products are, and as you guys know, they come out and they don't have hardly any hemp in it. The milligrams are all lies on the labels. So I'm excited to see where we can take this. This really creates a really cool portal where we can have a product people can believe in, just like we did with cannabis edibles. Nobody knew what they were getting when I was a kid. You get a brownie, you never know if it was 150 milligrams or 1,000 milligrams. So this is going to be really cool to be able to do this, but nobody's on board quite yet with it, obviously. So we're kind of writing history here in a way, moving forward. So there's a lot of unanswered questions as far as what other states are going to, jump on, but hopefully they follow our lead here.
Courtney Moran, OIHFA. I just want to follow up on Brent's comment that it was actually House Bill 4060 in 2016 that set the first requirements for mandatory testing for hemp end products. It did not take this last piece of legislation, but that he's right, we have not had the level of enforcement over that end product testing that we would like to see in the open market. So I look forward to these new provisions.
Thanks. And if there aren't any other comments, I think we can move on to our next topic here is child-resistant packaging. Anthony?
Actually, Stephen Massey, CDC dispensary. In terms of the 3-day business days under the camera coverage, we do have that for our destruction events in the shop, and it's I think maybe a little bit of a disconnect between us and other entities that may operate on a 5-day. We're open 7 days a week. So in the past, we have accounted 3 business days as 3 days that were open. So I don't know if this language needs a little more clarity for operations that are open 7 days a week.
Thanks, Stefan. Steve Crowley, OLCC. So business days is a defined term in these rules. It specifies Monday through Friday, not including holidays.
Excellent, thank you. So that's in the definitions somewhere, it sounds like. Perfect, thanks.
Hi, this is Anthony Galtoski for the record, OLCC. I am going to start going through some of the labeling changes that happened. Senate Bill 408 changes child-resistant packaging requirements so that usable marijuana no longer needs to be in child-resistant packaging. And these draft rules implement that change. It's in 845-025-7020, and that's on page 41 of the PDF. The update removes usable hemp and marijuana from having to be in child-resistant packaging. I will note a couple things here that licensees still can use child-resistant packaging. It's just not required. It's optional at this point, once the rule is implemented. And the other note is that licensees may have to update their packaging or labeling applications to indicate that they are not using child-resistant packaging. So that is one thing licensees will want to keep in mind if they do transition to non-child-resistant packaging. And as a note, and generally speaking, with most of these rules, these will not be in effect until January 1st of 2022. So as it stands right now, usable marijuana has to be in a child-resistant container. Does anybody have any questions about this?
Is it going to be the $25 change in a package and label approval for, like, for example, if we wanted to remove that child-resistant packaging and go towards more of a, I guess, non-child-resistant packaging?
Shane, would you mind just stating your name for the record?
Oh, yeah, sorry, Shane Patel.
Thank you, Shane. It's circumstance. It depends on the circumstances. So I can kind of broadly speak. As you all know, that the change request fee of $25 has been waived since I believe April of 2020 due to COVID. We are looking at reinstituting that fee. It is possible we may reinstitute it in January of 2022. However, we will absolutely advertise that that fee will be reinstituted and do our best to make that transition as smoothly as possible. So, if licensees do have specific questions, happy to respond to those via email with their individual circumstances.
Thank you.
Amanda? Yeah.
Thanks, Anthony. Amanda Metzler, Farms Inc. Anthony, so the child-resistant packaging for usable flower, that is eliminated, and also single use or anything. So we're talking about usable marijuana can come in any sort of container now, and that we need to get approved by you as well.
Yes. So it can come in any container that doesn't violate the rules. Basically, I'm paraphrasing here, but the container has to be sealed. It can't impart any toxic or deleterious substances, et cetera. But yes, more or less. And, everybody's labels are a little different, so I can't speak very specifically. So if licensees do have specific questions, just feel free to email me at marijuana.packaging. And the sooner you do that, the better too.
Anthony, Amanda Metzler, one more follow-up question. When we're submitting the labels or the label changes, do you want a submission of what that packaging is going to look like? The only thing is it doesn't have to be childproof anymore.
Yeah, so the licensing system requires you to upload a photo of the non-child resistant package. So in a lot of circumstances, you're just going to need to create a new package application with a photo of, let's say, that pre-roll box, the cigarette style box, and then associate that with your label. These are pretty easy steps, but you have to, as part of the labeling process, accurately tell OLCC what package the marijuana items go in. So it should be a pretty seamless process, but I will say that with the edible changes, which we'll discuss a little later, I'm going to get very busy. So if licensees do have questions right now, now's the time to start asking.
One more follow-up question, sorry, Farms Inc., Amanda Metzler. Does that usable marijuana have to leave in an exit bag then, or it can just leave in its actual container?
Anthony Galtowski, no, it does not need to leave in an exit bag. Retailers can do that if they'd like to, but it is not required by rule, or will not be, I'll clarify.
Thank you.
Gabe?
Yeah, thanks, Anthony. Gabe Partonley from Wild, and just quadruple confirming that edibles that are single serving edibles would have to be packaged in a resealable and continually child resistant container.
Yes, there's no change to basically the status quo for any other marijuana item. Usable marijuana and usable hemp are the only ones that are being touched. Everything else is status quo.
And Gabe Partonley again from Wild. That seems like an extremely, high addition of packaging. I mean, if we're attempting to move towards more sustainable practices with packaging, if that's what the OLCC is looking at, then transitioning away from these single serve packagings into more hard plastics with larger, longer lives, it seems to be counterintuitive, but that's something to think about.
Thank you. And I will note that OLCC is required to study packaging waste. We have to produce a report for the legislature. I believe it's the end of 2022. So it is something we are looking at.
This is TJ with OLCC. Sorry, just one thing, Amanda, on what Gabe's talking about. TJ with OLCC. The other thing I'd add here is that this is straight out of Senate Bill 408, and there was a discussion within the legislature about how broad or narrow this should be, and it was the legislative intent is specific to usable marijuana and not to those other product types. And so I think that there's, like many of these things, still a discussion that could be had in the context of the report Anthony was talking about, our future legislative sessions. But right now we're hewing closely to what the legislation and the legislative intent was specific to usable marijuana.
Amanda Metzler, Farms Inc. I want to follow up with what TJ said too, Gabe. We tried for that as well, and legislators are very scared about not child resistant packaging for anything food related that could go to kids. So while I don't think it's off the table, it's going to be a heavy lift, and there's just going to be a lot of education and things of that sort that will need to happen to get that change for the edibles as well.
Shane with Medicine Farm again. Just going back, kind of relating a little bit to that. I mean, topicals are, I feel like, would also kind of fall into that category too, of it being a non-psychoactive good, and potentially there just being a little bit less resistance, I would say, for moving those type of packages or marijuana items into non-child resistant packages.
Thank you, Shane. Do we have any more comments on the child resistant packaging for usable marijuana and hemp? Doesn't look like it. Let's see. So once again, Anthony Galtoski for the record. We're going to move on now to industrial hemp-derived vapor items. Senate Bill 96 directs OLCC, the Oregon Health Authority, and the Oregon Department of Agriculture to enact changes for hemp vapor items that are sold in Oregon. Note that there are no changes for hemp vapor items in the OLCC system. It is entirely status quo for OLCC licensees. Hemp vapor items on the general market must comply with essentially the same requirements that apply in the OLCC system. That is, label pre-approval is required. If the product has additives, full ingredient disclosure must be made to the OLCC and to the consumer on the label, and manufacturers must have a statement that from the additive manufacturer that the ingredient is intended for use in a product for human inhalation. And I am slightly paraphrasing here, but a hemp-derived vapor item is industrial hemp extract or concentrate that is more or less put in a vape cart. With that said, the rules that have been updated for this portion are in Division 25, 1015, subsection 4951. Those are on pages 8 and 9 of the PDF. There's a new definition for industrial hemp-derived vapor item, an inhalant delivery system. And these are both taken from statute. We've slightly modified the industrial hemp-derived vapor item to include non-cannabis additives, which is unique to the OLCC, and that will capture any additives that are being used in these products. In Division 25, 5045, and this is on pages 30 and 31, labs that are receiving non-metric hemp vapes must record them in metric via an external transfer and enter the results into metric. For waste, they must follow the same procedures as for metric tracked items. And moving along, Division 26, we don't have numbers for these rules yet because they're still in the draft status, but these start on page 66. And these are testing and labeling requirements that mostly mirror the existing rules for products in the OLCC system. As I just stated, they do more or less mirror our existing rules with some minor modifications that are unique to the circumstances for industrial hemp-derived vapor items. Tentatively, right now, we've got these rules effective on and after June 1st of 2022, and that's in our proposed language. We decided a 6-month runway was better to give manufacturers kind of a heads up because this is a new requirement. I just want to state that there will be a $100 fee for label approval, very similar to the OLCC licensing system. And the rules also allow, and this in Senate Bill 96, allow for the imposition of civil penalties for violating both the testing and labeling rules. If the person is not an ODA licensed grower or handler, if that person is, the ODA may institute civil penalties. And with that, I will open it up to any questions.
Thank you. This is Mitra Steckland with Extract. I have a question that is, let's see here, it's section 3B of 845-026-XXXE on page 69. It says requiring hemp vapor item manufacturers to provide informational material to a consumer at the point of sale. are there going to be more guidelines or specifics about what kind of informational material will be required for this?
Mitra, Anthony Galtoski for the record. Mitra, not at this time. These rules more or less mirror what's existing in Division 25, and at this time there is nothing being contemplated. Excellent.
Well, I'm really pleased to see this parts of the rules get built out, and you know, the same requirements as are in the OLCC marijuana side for labeling if there are additives besides cannabis items, because one thing that we've seen just anecdotally from buying hemp vape products off of like gas station markets and whatnot, and doing some testing with analytical labs, is that the majority of them do have additives like propylene glycol, and we've seen a lot of vegetable glycerin. We're seeing a lot less vitamin E derivatives now, which seemed to be perhaps what was causing the vape crisis a few years ago. But I'm very pleased to see that there will be a requirement for labeling similar to there is for the marijuana vapor items. Very much in support of this. Thank you.
Thank you, Mitra. Does anybody else have any questions, comments, concerns about these rules? Not seeing any. If you do have questions, comments, concerns, please send them to olcc.rulemaking@oregon.gov. The next thing that I am going to address is a possible labeling rule update related to artificially derived cannabinoids. At the artificially derived cannabinoid RAC last week, we heard significant feedback pushing to allow certain artificially derived cannabinoids, especially the non-intoxicating ones. Currently, consumers are not aware when a product they purchase contains cannabinoids that are made via chemical reactions that are not simply extracted from cannabis. If we do find a path to allow these products, OLCC believes consumers should make an educated decision as to what they are consuming. We are contemplating possibly a warning or an additional statement on the label regarding the artificial nature of some or all of the cannabinoids in the product. This requirement would be gradually implemented with a sell down. Does anybody have any thoughts on any additional labeling changes for artificially derived cannabinoids, should they be allowed in any form?
Gabe Partonley from Wild. I think that what we have in place already with, you know, defining whether it's an extract versus a concentrate, you know, can be used as a sort of framework for what we have for artificially derived cannabinoids, or however that ends up being defined. You know, currently we have a couple of products that have, or that may fall into this category, depending on, you know, which producer you talk to or which processor you talk to. And if it can be, you know, identified as an isolate, if it can be identified as a distillate or as an extract, or, you know, something more specific, that would be, you know, I think that that's kind of the most basic way to approach it. And, you know, and I think that makes a lot of sense versus, you know, an outright ban completely.
Brent, Kenyon, Anthony, I just want to, something we've talked about before is continue to push for, because the labeling is getting so intense with what we have to put on with the non-cannabinoid stuff now, that a suggestion I made a while ago, and I know it's been talked about a bit, is having a link on our packaging that goes to a website where the consumer can access all this information in depth, versus trying to have an insert or enough wording on a simple package to explain everything that's being used. I don't know if there's any movement on that, but I'd definitely like to encourage that we start moving towards that direction. It would be easy to have a small linkable scan bar on the packaging where people could go and find out anything they want about those products, and then licensees would be required, in my mind, to have that all on there available, including the stuff we're using for terpenes and all of that, just easy accessible. So it doesn't get any more, it's very difficult to try and fit all this on packaging. And companies like mine, we do a lot of white labeling. So it's not just one company or one brand that we're doing this for. I have several brands, so I have to submit each and every brand. As you know, Anthony, I bug you all the time. It gets tedious to try and keep up with all of this stuff and try and change people's packaging. You can't do a simple blister pack anymore. Now we have to add 2 or 3 business cards in those blister packs, and it's just, packaging is getting to be a nightmare with all of these type of additions. So I would encourage that we move towards a model that allows us to have that available for the consumer, but not necessarily immediately on the package.
Hi, Lizette here. Just kind of wanted to share on the retail side of things. It is of a concern to us anytime that we sell or a product that has a non-derived cannabis ingredient is presented to us. Just because we also don't know when the long-term effects of something like that when it is consumed either by smoking or by eating it. And so on that end, it does make us very nervous, and it's something that even when it first started coming out and people were buying it, we just refused to. It is all about cannabis, so it seems like all those extra additives are really unnecessary. But at the same time, we do believe that customers should be able to have the right to make their own decision as to what they want to buy. And I do like the idea of having some sort of link where you can really, it's all that information is easily accessible. But it's a lot of consumers don't really, some care, some want to know, some don't want to know. But it would be nice to see a way to kind of increase that education between the producer and I guess the shop and the consumer, so that the consumer can make an educated choice. A lot of the times, I also think that some companies that we've seen use those additives to kind of hide certain things that are put into the market. That damage in the product that it can affect taste or visually. And so that's also a concern. And then there's, of course, the ethical companies who don't do that, but we have seen a lot of things that just cause red flags. Thank you.
Thank you. This is Anthony for the record, and a couple of things. We have discussed QR codes as a means to access information in the past, but ultimately this comes down to an accessibility issue. Some folks may not have access to cell phones, internet. Some folks may not be familiar with how QR codes work. So it's very difficult to kind of, put information out of a consumer's reach where they can't immediately access it, especially when you're talking about, specific ingredients and products. But one thing I will point out is nothing in the rules prohibits licensees from putting QR codes on their products to link to more detailed information on their website should consumers want that information. Does anybody else have any more thoughts about possible warnings or statements if a product does contain an artificially derived cannabinoid?
Casey Lulayan here from the Oregon Retailers of Cannabis Association. I think one position that we've had really consistently throughout this process over the course of the last couple of years is that I think any of these specific regulations, especially as it relates to any notices around specific ingredients, really ought to be as much as possible rooted in the best available science that we have. So I think that we should really only be looking to pursue these types of additional warnings or requirements or labeling requirements for additives that we know to be problematic or that we know to have caused harm or could potentially have the capacity for that. And if we're dealing with products that we know have generally been available on the market for some period of time, I'm not sure that that's fully necessary if there's not any evidence to suggest that they could be problematic.
Steve Crowley, OLCC, just to kind of frame up the issue that we're thinking about. When people are purchasing cannabis products, they generally assume that the cannabis ingredients in there are cannabis extracts or things that are generated by normal either extraction or normal kitchen processes like heating or things like that. When we're talking about somebody takes CBN puts it through a cyclization reaction to turn it into probably a mixture of delta 8 and delta 9 THC, and then adds a chemical oxidant to turn that into CBN, and then purifies the CBN to the best of their ability out of that reaction mixture. It is absolutely possible to get relatively pure CBN from that process, but it's not clear that consumers know that what they're purchasing is not something that's simply been extracted from cannabis. And it's also not clear to what extent any research has been done on the byproducts of the cyclization and oxidation reactions. And so that's where this is coming from. Is that something a consumer has a right to know? Because I think at this point, most consumers purchasing these products are not aware that the CBN that they're purchasing is not something that was just extracted from cannabis.
Gabe again from Wild, and I appreciate that perspective, Stephen, and I'm just going to echo as Casey said. It should be rooted in science, and whatever if there are issues that come up, then the OLCC does have absolutely every right to to step in and interrupt a chain of commerce if there's issues that come up. We've seen it with vitamin E acetate, we've seen it with the vape crisis, and we've seen the capacity for the OLCC to act quickly and for the industry to respond. And for what it's worth, my understanding of why the Delta 8 issue came up and why this this whole sort of concern came up is that there are folks out there that are using very not pure or impure extracts in their products, which have a lot of unquantifiable byproducts from the processing. If there's a limitation down to what the actual product looks like, and there is a focus on back to a purified CBN, a purified CBG that's that naturally occurs in cannabis anyway, I don't see how there's how interrupting innovation in this sort of circumstance benefits the consumer, benefits the marketplace.
Thank you, Gabe. Do we have any more comments on the subject? If not, I'm going to turn it over to Stephen Crowley.
Thanks, Anthony. Stephen Crowley. The next topic that we wanted to tackle is hemp item concentration and serving size limits for the general market outside of the OLCC system. House Bill 3000 directed OLCC to establish limits. Kind of the background there is right now the only limit on THC potency in hemp products is that 0.3% threshold, which when you're talking about an edible is a tremendous amount of THC, in most cases more THC than marijuana items are allowed to have. There are many brands at this point that are selling products that are 10 or 15 milligrams per serving of hemp-derived Delta 9 THC, selling them in 10 packs, 20 packs, 40 packs, and selling them in all 50 states because this is, it's hemp, and at the federal level, 0.3% is the limit for THC in hemp products. The legislature was concerned to hear that there are more potent, there's more THC in some of the hemp products out there than is allowed in marijuana items. So that's kind of the background here. This is an issue that we actually have sort of tackled somewhat in the past. A couple of years ago when the legislature directed us to allow hemp products to be sold in OLCC retailers. The same issue came up in our rulemaking of wanting to make sure that the hemp products aren't containing more THC than the marijuana items. And so we established THC limits in OAR 845, 025, 2760. And so that's kind of what we've used basically as our starting point here for the rule number in the draft is 845, 025. or sorry, 845-026-0400. It's on page 64. And so kind of the hard cap is 0.3%. That's still, you can't, anybody other than a OLCC licensed marijuana retailer in Oregon can't sell hemp items to consumers that contain more than 0.3% THC. So, but the other limits that we've proposed are 1 milligram per serving and 10 milligrams per container of Delta-9 THC. For tinctures, recognizing that full spectrum tinctures may have significantly more while still having, you know, a large amount of CBD, allowing tinctures to have up to 50 milligrams of Delta-9 THC. And then for topicals, you know, just leaving the 0.3% limit as is, same for usable hemp concentrates and extracts, and then any other products, kind of using the same guideline as for edibles, 1 milligram per serving, 10 milligrams per container. So that's our starting point on this, but I'd like to open it up for discussion.
This is Mitra Sticklin with Ohm Extracts. In the draft rules language, let's see here, section 1A, 2A and 2B, it mentions about the, it meets the concentration limits permitted if, and then it says that the Delta-9 THC needs to meet, you know, this table 3 below, the 0.3%. But then it says does not exceed the maximum amount of THC permitted by more than 10%. And then section B says the same thing. So I was curious about that 10%, because that would put it all the way up above, you know, I mean, that would be like 10.2% THC potentially. Was that intentional?
Steve Crowley, OLCC. So that's a 10% above the threshold. So you know, if the threshold is 0.3%, then you know it can't exceed 0.33%. If it's 10 milligrams, you know, then it can't exceed 11 milligrams. That's the same sort of 10% grace buffer that OHA's rules have historically allowed for marijuana items, where you know, the limit for an edible is 50 milligrams. If your edible comes in 52 milligrams, it's within that 10% grace period, so that is still allowed.
Thank you for clarifying. That makes a lot of sense. Our read of this, we're definitely in support, and I'm curious in the chart where the items that say non-applicable, for example, the hemp topicals, does that mean that there is not a limit to those?
Correct. Yes, Steve Crowley. So yes, the hemp topicals, no milligram cap per serving or per container, just a 0.3% limit. Same for the usable hemp concentrates and hemp extracts.
Mitra Sticklin again, Ohm Extracts. We're definitely in support in general. I would advocate that the hemp transdermal patches mirror what the hemp topicals show, because they are also used topically. And there's not really, in my understanding, any way to overdo it on the THC with a transdermal patch.
Thanks, Mitra.
Hi, Gabe Partonley from Wild again, Wild CBD, I guess this time. So to make sure that I'm following, so 845-026-0300 defines the adult use cannabis item as anything that's 0.5 milligrams or more within the package, and then the upper limit for any hemp item would be 10 milligrams of THC per package.
Correct, yes. Yes, the upper limit for anything on the general market, the limits in 845-025-2760 still apply for hemp items sold at an OLCC licensed retailer. So, for example, those allow usable hemp to have up to 1% THC instead of the 0.3% cap here.
Okay. And so I'm thinking more towards the, sorry, this is Gabe again from Wild CBD. I'm thinking more towards the open market outside in, you know, the natural grocers of the world. Is there still any discussion about whether that 0.5 milligrams per package is the final number? The reason I'm asking is that, in general, most labs, I think the lab regulation is something like, you have to be, in order to have an LOQ reading, it has to be some, defensible number that's so significantly under 0.3% that folks would be fine with it. I think that most labs that I've seen use, about a tenth of that, so a 0.03%. And changing the standards, changing the processes to get down either to a limit of detection or that 0.003%, ultimately increases testing costs and operational costs by 20 to 40%. And I just wanted to get that one out there on the record as a fiscal impact for having that significantly lowered total THC per container.
Steve Crowley, OLCC. So yeah, in our current rule package, we aren't looking at changing the 0.5 milligram limit. Just to clarify, are you recommending that it be the language in that be changed from limit of? Well, actually, I think 0300 doesn't use the term limit of quantification. So as long as their limit of detection is sufficiently small and it comes in, is not detected.
Yeah. So sorry to interrupt. It does use the LOQ. This is Gabe again from Wild. In 845.026.0300, it uses the LOQ in subsection 1C. Testing in accordance with blah 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 is not sufficient to demonstrate, or using a method with an LOQ that is not sufficient to demonstrate does not exceed 0.5 milligrams. So it does, refer back to that LOQ number, and so it does, force processors to go back to, some, rather significantly increase its cost of testing per batch, or switch to sort of an LOD testing where it's a pass or fail.
Yeah, so on that one, would you recommend changing it back to the original language, just that has not been demonstrated to contain less than 0.5 milligrams, so that a non-detect with a sufficiently low limit of detection can satisfy that requirement?
Yeah, I mean, if the Gabe again from Wild again, if I would suggest, if it doesn't sound like it's open for discussion at this point, that the milligrams increase be to 5 milligrams per package as the threshold for determining what's an adult use cannabis item, or to have testing in accordance with 571330 or 57339 that demonstrates that the product is shows a total delta 9 THC of LOQ is sufficient to demonstrate that the product does not exceed whatever number.
Steve Crowley, OLCC. I mean, I think there is concern with letting children buy 5 milligram units of THC.
Understood. Yeah. I understand the concern, and I am speaking solely as from our business with our 40 packs of gummies. I think a child will have more problems with diabetes than they will with THC, given our products, but such is life.
Thanks, Gabe. Any other feedback on the hemp potency limits?
Yeah, hi everybody. Courtney Moran, Oregon Industrial Hemp Farmers Association, also serving as proxy for Ann Johnson with PacWest. We went into this in detail last week. We are opposed to the current table here that has these concentration limits as proposed. These limits are going to make it very difficult for hemp industry participants to continue to operate, and it is going to have dramatic financial impacts. Many of our members have explained to us that these current proposed concentration limits are going to require them to change their formulations and require these businesses to completely change to selling only outside of Oregon, or that they are actually going to pick up and move their operations outside of the state if these regulations go forward. And many folks, both within our organizations and just general clients I have in the industry, have been calling me over the last week, letting me know that they're very concerned about these rules going forward, and they do think that they are really being forced out and being forced out of the state with these current rules, and that these proposed concentration limits are sending the wrong message not only to our Oregon participants, but to the national hemp industry as well. And so we have sent you our proposed table for more reasonable limits. I'm happy to discuss those with you further. So thank you.
Amanda Metzler, Farms Inc. I'd like to follow up on what Courtney is saying. We on the OLCC licensed farmers disagree with Courtney's position. We feel that we have, with the rules and regulations that we have to follow, that hemp does not, that gives us exclusive rights to sell intoxicating products. That's why we jump through the hoops, and that's why we're doing it. If the hemp industry cannot survive by selling non-intoxicating products, then you aren't doing what the hemp industry is supposed to do. OLCC and THC farmers grow intoxicating products. Thank you.
Yeah, Courtney Moran, Oregon Industrial Hemp Farmers Association. We're not talking about intoxicating products here. Yes,
Chief Crowley, OLCC. So yes, Courtney, we did receive your feedback in the rec last week. And so one of the proposed numbers was 100 milligrams per container for edibles and 2.5 milligrams per serving. I just wanted to get that on the record here. So, to Amanda's point, to let the OLCC licensees or other stakeholders here kind of weigh in on where they stand on the number in that kind of.
I think what the Amanda Metzler Farms Inc., what OLCC has proposed here is nice, and we are supportive.
Casey Houlihan here from Oregon Retailers of Cannabis Association. I'd like to echo what Amanda is mentioning as well. I think that's been a lot of the concern from several of the folks that we've worked with, as well as the ability to get what are ultimately, or what constitute intoxicating products based on the levels of THC available in them from non-OLCC sources. I think that's something that we'd all like to see reined in.
This is TJ with OLCC. Courtney, I had one follow-up question for you. You mentioned that you've been hearing from your members that under these limits proposed, they would move to other states or sell exclusively in other states. One of the limits you have proposed for industrial hemp concentrates or extracts is 3%, hemp tinctures 1%, hemp topicals 2%, all of which are above the federal 0.3% cap. Could you speak to what your members are saying in terms of what their market would be for selling something that exceeds U.S. Farm Bill limits in other states?
My folks are open to conversations in regards to looking at, of course, a 0.3 delta 9 when you're talking about total THC in regards to end products. There's definitely, I would say, differing opinions on what the 2018 Farm Bill says in regards to end products versus what the USDA final rules say in regards to pre-harvest requirements. And I mean, we're open to, looking at these different numbers here, but what the limits that you have put out here now will require folks to completely change their formulations.
Amanda Metzler with Farms Inc. This industry has been going on since 2016, Courtney, and we have had to change everything again and again and again and again and again. And I'm sorry for OLCC licensees that have been here from the beginning. Your argument that they're going to have to change something is heard on deaf ears.
This is Mitra Sticklin with Ohm Extract. One thing that we were talking about on my team in terms of consumer safety and making sure that people don't have access to intoxicating products in the industrial hemp side would be having similar kind of child resistant requirements, especially for edibles, as was mentioned before, something like that, that for the things that'll be like most likely to look appealing as opposed to something that looks like medicine, just and doesn't taste delicious. So, but that was something that was brought up on my team, and I just wanted to share as some insight whereas something like a topical transdermal patch, yucky tasting medicine is not going to be something that accidentally gets consumed. I think that something that is delicious or looks really appealing and yummy is something that might be of more concern. And so perhaps the packaging side of it could tackle that at some point down the line. Thank you.
Mia Getlin here, Gleam Law. I'm not going to speak to the specific limits. I'm going to leave that to the people with more direct experience there. But I do agree that if it's something that's going to get you high, it needs to be regulated like something that can get you high. And if that's not the case, then OLCC licensees shouldn't be regulated like they are. Just there needs to be parity for products that get you high and how they're regulated.
Steve Crowley, OLCC. I guess just to kind of get a sense of where our target limits are, either Courtney or maybe Alan, could one of you address what portion of the hemp product market actually exceeds these limits, the 10 milligrams of THC in an edible, 50 milligrams of THC in a tincture? Is that a large segment, or are we kind of looking at outliers? Just kind of ballpark numbers would be helpful.
Courtney Moran, Oregon Industrial Hemp Farmers Association, proxy for Ann Johnson. I will tell you that my members are more so concerned about the limits that you put in regards to hemp tinctures and concentrates, less concerned about the edibles concentrations that you put out here. I mean, 10 milligrams is, they consider that unreasonable. I think we can definitely have a conversation about something smaller than the 100 milligrams. And, my folks were really focused on providing much smaller serving sizes than anything that is allowed within the retail dispensary system. We're not trying to get people high. We just want people to have access to products that provide more of a full cannabinoid profile, not products that are getting people high. So for specific numbers, Stephen, I'd have to follow up with you.
Thanks. I guess I'll give one more, just last call for any last thoughts, and then I think if we could take a short break and come back and we can talk about the marijuana concentration and serving size limits when we get back. Any last thoughts on the hemp limits?
Mitra Sticklin again with Ohm Extracts. Just one response to your question about the limits around the hemp tinctures. One thing we observe in local health food stores around our area in Southern Oregon is that while most tinctures are being sold in a 1 ounce bottle, they are also sold in 2 ounce, and now we're also seeing 4 ounce bottles. And so while it's still going to meet that 0.3 percentage, of course, that total amount in a container will go up. However, a lot of patients that want to, save money and buy less packaging, have a lighter carbon footprint, are going to choose to buy a larger package of a tincture. So we are seeing a lot of rise in popularity of those 2 ounce and 4 ounce sizes of a full spectrum CBD tincture on retail shelves around here. Thank you.
I'd just like to add, this is Shane. I think that kind of echoes the OLCC tincture definition, kind of how that worked, right? It started as 1 ounce packaging, and then everyone kind of moved to syrups to kind of get around that, to get some sort of different around the edibles versus tincture milligram potency limits. So I think this would play, that trend kind of continues on the hemp side of a thing, where the package size will just keep increasing. Therefore, the potency size will just keep increasing, or the amount of THC inside that package will just keep increasing.
Thanks, Shane. So yeah, I think at this point we can take a 5-minute break, try to get back at around 3:55, and we'll dive into the marijuana concentration and serving size limits.
Okay, once again, this is Anthony Galtoski, OLCC, and we are continuing the bill and technical rack. The next thing we are going to discuss is the concentration and serving size limits for marijuana items. Senate Bill 408 and House Bill 3000 transfer the concentration and serving size limits for marijuana items from OHA to OLCC and require edible limits to be up to 100 milligrams of THC per package. And the rules that address this are in the new Division 26, 200 and then 220. And this starts on page 60 of the PDF. As many of you know, OHA formerly had these rules, and what we've done is we've mostly mirrored them. And as I just mentioned, edibles can now have up to 100 milligrams of THC in the container and 5 milligrams of THC per serving. So the 5 milligram is a leftover from the old rules, which had the same limit. However, after engaging with our public health partners and surveying other recreational states, we have created a requirement that if a solid edible exceeds 55 milligrams of THC, it must be scored. And scoring does have a specific definition, but ultimately means that self-portioning via serving diagram will no longer be allowed for solid edibles that exceed 55 milligrams of THC in the package. And we also are looking into revising this requirement for all edibles and may adjust the rules in the new year. However, as it stands right now, this scoring requirement would be applicable to products that exceed 55 milligrams of THC and are solid. I believe we have Julia Dilly online. Julia, if you're here, would you mind introducing yourself and speaking a little bit about why these requirements are important? Thank you.
Sure. So I work on a federally funded research grant looking at public health and safety effects of cannabis legalization in Washington and Oregon, and also do a lot of work in Alaska. And this rule is of great interest to me because we have been using national level poison center data to look at edibles, poisonings, cannabis related edible poisonings reported to the US poison centers from different states, especially for kids. So usually under age 9 is what we're looking at. And I'm sure it's not a surprise. There's been other studies, including some of our own, that show that edibles are an issue for kids. You know, if you have a chocolate bar that's laying around and, you know, despite best intentions, it's easy to leave things around that kids will get into. And then if kids get into a chocolate or a candy, you know, that can be pretty tough on their systems. So we've been looking at different states as patterns of calls to poison centers for kids and cannabis related exposures. And I guess the things I wanted to share with this group were that for one thing, we've been looking at it, again, as I mentioned, specifically by state. Washington seems to be doing a little bit better in terms of rates of cannabis-related exposures for kids, for small children. That could be related to their requirement to have individually wrapped chocolates and, you know, edibles, so that, you know, if you have a kid that finds an edible next to the couch or, you know, somewhere where they can get into it, if the servings are individually wrapped, there's sort of a natural stop for kids. You know, it requires more work for them to get into more of the product. So so it looks like Washington has got a little bit lower rates of exposure for pediatric cases, and that seems like a good thing. So I guess we were looking at that. I wasn't really meaning to look at Oregon specifically, but in the process of looking at all states, I guess the other thing I wanted to share was actually Oregon's rates look a little bit higher than other states, and so that's kind of concerning. Yeah, so I'll just share that it's kind of concerning. And certainly when we're looking at the different packaging options that are out there, I guess if I was going to design one from a purely public health perspective, it seems like what might be the best for public health and safety would be something like individually wrapped servings, you know, plain packaging that wouldn't catch kids' attention, and of course a lower THC concentration per serving, like what Oregon has now, the 5 milligrams per edible. So those are the things I just wanted to share with this group, and our research is ongoing. And I mean, I know that, you know, health and safety for kids is a priority for everybody. So I just wanted to share that with you as you're thinking about packaging rules.
This is Jess Nyworth with OLCC. Julia, just as a follow-up, when you look at poison center data and marijuana exposures, can you kind of connect the dots between what we're seeing in exposures compared to what types of products, and how that relates to packaging, the packaging conversation we have in front of us today?
Mm-hmm. It's a little tricky because the poison centers didn't add product-specific codes until 2017. So for our historical data, when we're looking at long-term trends, all we know is that it was some sort of cannabis product before 2017. But from 2017 to 19 is when we started to have detailed cannabis product information. So from there, we know about whether it's edibles, whether it's concentrates, whether it's flavored or unflavored, vape liquids, and that sort of thing. So a lot more detail there. What we know about from those years of data where we have more information available, we know that when you're looking at pediatric exposures, the vast majority of them are edibles. And I guess what I don't have, and maybe this is what you're asking, Jess, I don't have like whether it was a chocolate or a gummy or some other like greater level of detail. We just know edible. Does that get at what you were thinking of?
This is Jess Nyworth with OLCC. Yes, thank you for talking about the types of products that are showing up as kind of unintentional poisonings and exposures to young children. You know, as we look at the language that OLCC is putting forward about the serving sizes and indications on the packaging and labeling, what we have not put forward are other public health recommendations like individual wrapping or something similar to what Canada has, which is 1 serving per container. What OLCC is putting forward instead is the status quo for existing edibles under the existing limit of under 50 milligrams, and then for larger products that they must be scored and easily identifiable.
Yes, hi, Lisette with Cannaband retail facility. I really do like the idea of having the edibles scored if they're higher than the 55 milligrams. One of my concerns for having individually packaged or servings, one is also just already the amount of crazy packaging that our industry creates and waste that comes along with that. So we do need to find ways to kind of try to minimize that problem. But also there's several people who need it for medical purposes, need that higher milligram, and it is really difficult and sometimes in a bad medical state that you're in to try to eat 5 different gummies or 10 different gummies once they're individually wrapped, or even just go through that. You know, for somebody who's sick, sometimes you can barely eat the 1 serving thing. And so just something to keep in mind in that sense. And also I do think it's more of a parental issue when it comes to access that kids have. You know, we're already working a lot with the packaging and not making it appeal to children. But you know, it's just like with alcohol, like we are responsible for where we keep that and educating our children and making sure that they don't have access to that. So to me, that's a little bit more of a parental matter. And I do have 3 children between the ages of 5 and 10. Thank you.
Yeah, Brent Kenyon, just real quick.
This is Jess from OLCC. I just want to respond to that. The FDA actually says about 75% of unintentional poisonings can be prevented by child-resistant packaging.
Right, Brent Kenyon, Oregon Original. I was gonna pretty much mask that. Child-proof packaging is the only guarantee I mean, my 5-year-old will sit and open up Starbursts one after another until you take them away. So ultimately, separate packaging isn't going to necessarily help keep a child from getting more dosages than just one. They're not going to stop because it's too tedious to open the package. So child-proof packaging is the only sure way, and that's not feasible in a lot of instances for businesses that are running and trying to find the right packaging, and a packaging that's attractive to customers but not necessarily to children. So having a black and white, we had these discussions early in the early racks of it's not feasible to have any business that's held to a black and white package because children might get into it. I mean, the liquor industry the same way. There's all kinds of fancy bottles that are labeled wonderfully with bright, colorful fruits and whatnot. So, I mean, the thought that there's any way we can control, you know, children getting access to stuff they shouldn't, I agree, it's a parental thing. And if that's not handled in the home, and we've had to do this in the medical industry for years, keeping products away from children. All those medical patients had kids at home. And so, and I would be interested to hear the numbers that you have put together also, what the report was in those 2 years that you have available to you in Oregon and Washington. Washington has all kinds of colorful packaging. I was just there in dispensaries looking at them. I'm in California a lot. They're out of control down there. If there's any state that needs reining in, I mean, they have, between the black market and the legal market, they've got copycat kids candy packaging now with cannabis products in them. So I think Oregon's right on point with what we've been doing. We've got a reasonable packaging rule set up. Anthony is very good at what he does to try and monitor and make sure those things don't look too cartoony. But overall, I think we've done a really good job where we have it now, and the child-proof packaging just doesn't make sense for the long run of an industry.
And as a dispensary, we also use exit packaging, which is another extra added form of protection for those that should not be getting into the product. So there's that as well.
This is Anthony Galtoski, for the record. And so one thing I want to clarify is the rules as they stand right now don't require individual wrapping. They just require them to, if it exceeds 55 milligrams, it's required to be scored. And the other thing is medical edibles are not required to be scored. They can be, but they're not required to be scored. And the other thing that we are looking at here, it's the scoring helps reduce accidental ingestion by children, but it also helps with ordinary folks that are your customers over consuming accidentally, because we see a lot of these comically small 10-gram gummies with 50 milligrams of THC, and the consumer is supposed to cut these up into 10 pieces. And so we do know a lot of consumers, we do have reports of consumers accidentally are over consuming these products. And so that, that's a big concern as well.
It does make me wonder the difference of why medical edibles over 55 milligrams do not need to be scored. It just seems like a lot more work for the edible company or the company, and even an added cost.
Hi, this is Gabe Parton-Lee from Wild. I wanted to clarify one final time that the current rules that allow for, pictures on the packaging to identify, eat half a gummy and, it has the picture on the packaging, would it still apply for a 10 milligram single gummy? It's not required to be scored. It can be scored. The only scoring rules apply at 55 milligrams and above of THC.
Gabe, I'm trying to look at the rule real quickly, but I don't think that this rule that we've created has a carve out for 10 milligram products lacking to be scored, but I may be mistaken.
This is TJ with the OLCC. I think that the intent here, Gabe, was to leave. Our concern primarily is if you take the same 8 or 10 milligram single gummy and instead of 50 milligrams suddenly has 100 milligrams. So to a degree, the status quo is a little bit sunk in terms of cost and expectation. So that's where that 55 milligram comes from. It's the 50 milligram plus the 10% buffer that's in rule currently. So it's creating a bifurcated standard now of anything above that potency. It can still be in that same, it would have to be scored or be the same size with the same expectations as exist now, under 55 milligrams.
No, thank you for the clarification. And I did want to, and I suppose that my confusion comes from that, the way that it's written, the solid cannabinoid edibles that exceeds 55 milligrams in the package. So, if we have a 100 milligram package with 10 gummies in it, does each one have to be scored, or can the pictograph that's currently allowed, for identifying how much to eat of each single gummy, is that still in place for those types of products?
Assuming each individual gummy has 10 milligrams of THC, as it stands right now, they'd have to be scored.
Great, thank you. That's how it is. That's how it is in California as well. And so just making sure that it's aligning with everywhere else in the state or in the US.
Yeah, and this is Anthony for the record. And I did do a very extensive state survey, and Oregon is absolutely an outlier in allowing people to self-portion and use these serving diagrams. Every other state requires scoring, or most states, I'll clarify that.
Hi, Mary from Lori and Mary Jane here. If we are trying to align more with other states, is there talk about doing 10 milligrams per serving instead of 5?
This is Jess from OLCC, and no, it's at 5 milligrams.
This is Mitra Sticklin with Ohm Extracts. One thing that came up on our team as we were going through the updated charts and reviewing the current versus proposed versions. One thing that we had a question about is around the cannabinoid suppositories. In the retail chart, it's listed along at that last line with a 5 milligram per serving limit and 100 milligrams per package. And then it's actually its own line item for the medical. We would advocate having it be its own line item for the retail as well, and having pretty high limits, similar to what a tincture would be, because it is a product that we believe should be available adult use for anyone who wants to, but it's clearly a more medicinal leaning product. But we don't think that people should need to have a medical card to be able to access higher dose suppositories. And one of the main reasons that you don't see suppositories on the OLCC market in the way that they were back in the medical dispensary days is just because the limits don't pencil out with the cost to make them. So a lot of patients, what we advocate when patients reach out asking for suppositories, we basically have like a number of different resources and PDFs and videos that we can share about how to make them at home. But we haven't been able to produce an affordable suppository on the retail market because of the limit size and the cost to produce and package and label and whatnot. So we would advocate having that be its own line item and having similar potency limits for retail that the tinctures currently have. Thank you.
Thank you, Mitra. Gabe?
Gabe Parton-Lee from Wild. I have two kind of questions. One is, how would you define the difference between the cannabis products edibles and the cannabis product or cannabinoid product capsules? And what's the justification for having different serving size, THC serving size, per serving sizes for those two, seemingly very similar products? And then the second one would be, relating to cannabis beverages or cannabinoid infused beverages, how to approach those in general with the increased potency limits.
Anthony Galtoski for the record. In terms of the edible beverage potency limits, I'm not quite sure what you mean, Gabe. The lack of scoring, is that what you're getting at?
Yeah, the lack of scoring, Gabe again from Wild. Lack of scoring, just, sort of identifying how much of each, how much to use in each, how much to drink with each sort of serving. If you have a can of 100 milligram THC soda, how do you, as a business, correctly and adequately identify, through picture or through single serve dropping or whatever, how to identify how much is a serving?
Anthony Galtoski for the record. So as it stands right now, it can either have markings on the exterior, that are accurately dosed, or if they don't have markings, or if it can't be accurately dosed, such that the package is curved or whatnot, they can include an approximation for a common household measuring device, like a teaspoon, a tablespoon, followed by the milliliters, because household measuring devices are not uniform. So as part of the label pre-approval process, they have to put the milliliters in there. In terms of capsules, I know capsules have a distinct definition and rule. And as I mentioned, we simply ported over OHA's rules. We haven't had an in-depth discussion among staff of increasing or changing these limits. So I don't really have much to add on that. If anybody does have any public comments that they'd like to issue to those, olcc.rulemaking@oregon.gov.
I think it makes, Mary from Lori, Mary Jane. I feel that it would make sense to increase the serving size to 10 milligrams, especially if we're trying to align ourselves with other states. And, particularly with the scoring of edibles, that's going to wind up being 20 scores on a 100 milligram item, which just seems like a lot and a little difficult probably to read at that point. Additionally, solid edibles still come in all sorts of shapes and sizes and forms. And just having one rule for them to be seems a little bit restrictive. Like for instance, if it's something that's powdered, it's not liquid, I would assume that's solid, and how would you measure that? How would you score that? So I'm just, if it could follow more along the lines of what we currently have, obviously that would be helpful, but if there can be some, something else we can do besides just scoring, that would be great.
This is TJ with OLCC. Mary, a follow-up question on the 10 milligram point. Everything that we've heard, and even this came up in 2016 when the concentration limits were first being established by OHA, the idea that sort of the naive user, the new user, the recommended doses is 5 milligrams or less. Do you, or I guess I'd open this up to others on the rack, any recommendations on if the serving size were 10 milligrams, how you then balance also the idea that, a newbie serving size isn't 10 milligrams, it's half of that, how to sort of clearly demarcate that piece of it?
This is Gabe from Wild. I can jump in and answer that one, Mary, unless you want to, because I would echo also that I think that the only state right now, other than Oregon, that has a 5 milligram limit is out in Massachusetts. Alaska, Julia brought that one up, is switching to a 10 milligram per serving limit as well. And so we, while we, were an outlier in the scoring, we're now an outlier in our THC concentration per serving. And TJ, to answer the question about how to inform consumers, eat half. I mean, that's the best way that we can think of of informing consumers is start low, go slow, and expect that you're going to, you have the capacity to measure your dosage. And that's the point of the control studies. That's the point of the testing. That's the point of the homogeneity, is that, the edible products in Oregon are the best products that exist in the US. And it's because we have, rigorous lab testing where we can say eat a third and you can be pretty confident that you have, you know, a third of what the actual potency limit is for any individual gumming, regardless of the per serving size.
Sunny Hart. From a retail perspective, consumers that are just starting out typically don't start off with the 100 milligram package. They're going to start off with a package that's 25 milligrams or 50 milligrams. And then those packages would be very simple to have the 5 milligram serving scored 10 times or 5 times. And then having a different standard for a 100 milligram package. Those are the consumers who consume regularly and want the higher THC for the value of it. And then having that one, if it's 100 milligram, having the serving size be 10 milligrams to match everybody else just sounds like a good way to follow what everybody else is doing.
Amanda Metzler, Farms Inc. Again, Gabe, we tried to get this to the 10 milligrams at the legislature when we were doing HB 408 and got pushback. So this is something that we can revisit again, but it's going to be a lift for it. The legislators need to get more educated, and that's where the pushback came on changing it to the 10.
Thanks, Amanda. And yeah, and this is Gabe again from Wild. I appreciate that. But again, this is, you know, ultimately a regulatory decision that's up to the OLCC. And, you know, that's, you know, the legislature didn't set the 5 milligram limit. It is the OLCC that's setting it. And, you know, based off of what the national scope is looking at and how, you know, we want to fit in with the expectation of federal legalization in the next 4 to 12 to 35 years. You know, we want to be sure that we are in line with everybody else, regardless of how long it's going to take for us to get to some level of interstate commerce or some level of federal legalization.
Casey Houlihan here with the Oregon Retailers of Cannabis Association. I also just wanted to reiterate some of Gabe's comments, especially around some of the public safety concerns or the perception of public safety concerns around what to do if we do raise up a starter dose to 10 milligrams. I think, you know, starting smaller or trying half a dose is a really appropriate message for folks who are going to be otherwise new consumers to this. I think you can also look at several OLCC sanctioned alcohol consumption devices. I'm thinking of Brewfests and things where a serving size of alcohol is clearly smaller than a typical alcohol unit because people are, you know, it's under the assumption that people will be trying multiple products throughout the day. And so, you know, we already have some basis of comparison on the alcohol side with people trying, say, a 4-ounce beer serving or a 6-ounce beer serving as a sort of sampler or starter. And so, you know, there are ways to kind of skin this.
Just with OLCC, just now with OLCC, I'm curious, Julia, if you have any data on the emergency department or hospitalization visits for other audiences besides young children. So we have talked about education in the home, but also education to the consumer themselves. As we've seen in other states, there are still a significant number of hospitalization and emergency department visits and poison control calls post-legalization, regardless of the education efforts. What are you seeing here in Oregon or kind of national trends?
Mm-hmm. So a couple of thoughts. One is we have been looking at poison center data, not just for kids, but also for adults. So stepping back for a second and looking at that across states and anticipating that there will be increases after Alaska has gone from 5 to 10. So we'll be watching that, and I guess just know that we'll be watching that. In terms of emergency department visits and hospitalizations, that's the data around those have been difficult to track during the pandemic because people have avoided going to the emergency department unless they absolutely had to. So the numbers have been a little bit all over the place for all kinds of healthcare visits, not just obviously cannabis related ones. But prior to that, we were seeing increases overall, and I hadn't gotten to the step yet of trying to, what we could do would be to look at pre-pandemic trends in emergency department visits across some states. And we haven't gotten to that point yet because we've been working with the Poison Center data first. But that is a positive. I mean, we know that overall emergency department visits have gone up and among a variety of age groups. So it would be a natural replication that we could do with that data set versus the Poison Center.
This is TJ with OLCC. Just a follow-up question based on what Sunny was talking about, and we're running short on time, so I'll just ask people if they do have feedback on this to submit it to olcc.rulemaking@oregon.gov. But we've heard from some folks saying that once 100 milligrams is available, then there's not going to be a market for 50 milligram products or anything less. Whereas Sunny, you were just talking about how new users are the ones using 25 milligrams or 50 milligrams. So we'd be curious from retailers or processors, if you have multiple product lines based on potency, to get data on market share of sort of those different tiers of potency. That would be helpful for us, I think, to in especially on the serving size piece.
Thank you, TJ. This is Anthony Galtoski for the record. The last piece I want to discuss, we did increase the transdermal patch limit from 50 milligrams of THC in the package and 5 milligrams per serving to 100 milligrams of THC in the package and 10 milligrams of THC per serving. Does anybody have any comments regarding this change?
This is Mitra Stickland with Extract. I think that increasing the limit makes a lot of sense. At the same time, in my mind, they are really the same and used the same as a topical. So having it just mirror exactly what the topicals have makes more sense to me. And it doesn't seem like something someone could overdo on the THC side from my perspective and my understanding of the science. Definitely agree that it should be raised, and I think that the 10 milligrams is certainly twice as good as it was before. Thank you.
Brent Canyon Oregon Original, I agree with that. Topicals should mirror topicals. It's a topical.
Thank you for the feedback, everyone. I will now turn it over to Stephen Crowley to discuss technical fixes that are in this package.
Thanks, Anthony. Stephen Crowley, OLCC. So there are a number of minor clarifications throughout these rules in 845025, 5700, 5730, 5760, 5790, 7030, 7160, 7700, and then 026, 0100. Most of these are pretty minor clarifications to testing issues or to recalls. There's a clarification that the principal display panel for a short wide item is the top surface. And for approved labels, there's a change to allow certain changes in business name, trade name, or license number without label resubmission or pre-approval in certain circumstances. As Amanda touched on, the route information is no longer required in metric, and it allows the transportation to be done by representatives of a license under common ownership with the originating licensee of the transfer. And then also just a clarification on what is an adult use cannabis item to make clear that adult use cannabis items do not include non-cannabinoid hemp grain or fiber products. So I know that was kind of a lot of different little things, but if anyone has feedback on any of those, we would love to hear it.
This is Anthony Galtoski for the record while everybody's thinking of their feedback. I just want to provide one little bit of clarification on the labeling change in 7160 subsection 8. And this is the rule that allows licensees to change certain things on their label after it's been pre-approved. So things like strain name, UID. I did start to see that the reality of the fluidity of the marketplace for wholesalers and retailers changing the producer's name and license number just isn't realistic to have to resubmit that every time. So what the rule says, basically, if a wholesaler or retailer has an approved label, they can change that information without resubmission pre-approval.
All right, and if there's no other feedback on those minor clarifications, we have some even more minor clarifications in here. Basically, from the middle of page 76 onward to the end of the document, it's just all housekeeping changes, updating references, you know, statutes have been renumbered, formatting corrections, things like that. So nothing really substantial in there, but those are all also included in the draft language. So any feedback on those, or I guess just any closing thoughts on the changes overall?
Amanda Metzler, Farms Inc. I wanted to ask TJ, is there going to be guidance on what the farm-to-farm transfer of common ownership is going to look like and how we're able to do that, and if tags need to be involved of that sort? Is that something that still needs to be fleshed out?
TJ with OLCC, it's going to look like retail to retail common ownership looks now. There's no changes that are going to be required or warranted in Metric. It's going to be the same as any other transfer to any other license.
Follow up. This has been my problem from the beginning, is that if we're going to be transferring from farm to farm and I have to tag every single plant to transfer it to my other farm and then re-tag it at that license, that is now a double tag that was supposed to be eliminated by this farm to farm transfer of common ownership.
Sorry, I misunderstood your question. I thought you were talking about finished product. So there's not going to be a change. Metric require only packages can be transferred in Metric. That's a basic system function. So to open it up to plants directly being able to be transferred, we'd have to explore that, and it's not going to be by January, certainly.
Well, this is something I've been pushing to have explored for almost 4 years now, is that currently you have to tag a plant, and then if you want to transfer it to your other farm, if it's above 24 inches, then we have to re-tag it when we get to our new farm and put it into a package of the new farm. And that's what this whole farm to farm transfer was, I was told, was supposed to eliminate, were these double tagging that needs to happen between farms. So I know that there was conversation about maybe taking off the 24 inches of when the plant has to be tagged. So then it doesn't, so then there isn't this double tagging, but allowing this common ownership of having farms, now we're going to have double tags. So instead of 50 cents, it's going to be $1 per plant.
So I'd encourage you to submit comments during the comment period on specific scenarios that you're talking about that would be subject to this double tagging you're talking about. I'd say a couple of things. We're exploring ways to minimize tag costs overall. So as one example, we put out a bulletin yesterday talking about a rule change we made that we'll be making permanent, as well as an upcoming system change in Metric to ease the labor costs on harvesting and data entry on plants. We'll also, the next contract with Metric that starts January of 2022 will start discussions on the batch tagging of plants generally. So really, it's going to come down to time and resources on our side and Metric side of looking specifically at what you're speaking to of changing how transfers work with plants versus a more fundamental discussion of how many plants have to be tagged and the costs of tagging generally. So it's basically a question of prioritization. So your comments, submitting comments, quantifying it in terms of the number of plants you're talking about, cost, those sorts of things would help us in those discussions internally of where we prioritize our time and resources within the contract.
TJ, with all due respect, I've actually submitted those comments over the past 3 years to all levels of the OLCC, and I also sit on the Metric user group and have gotten shut out of that as well. For this conversation to have about the double tagging. Currently, when we tag a plant and transfer it over, you make me say when it was replanted and make a fake kind of planting anyway, which isn't great for public safety. There is no tracking back to it when I'm like creating a planting from a package. So I think that this is something that really needs to be addressed, not only from a financial thing, but also from a public safety standpoint.
Thanks, Amanda. Any other closing thoughts before we get to fiscal impact? All right, so with that, I will hand it back over to Amanda Borah.
Wasn't quite right for that. I think I'll be handing it over to Jess.
And the second. So hi, my name is Jess Nyworth. I'm the Public Health and Safety Analyst at the Oregon Liquor and Cannabis Commission. This time we'll move on to the Fiscal Impact Statement and Public Health and Safety Questionnaire. And we'll collect general feedback from the group regarding the possible fiscal impacts of this package. But for those wishing to provide additional feedback, please complete the statement and return it to us within the week by mailing it to olcc.rulemaking@oregon.gov. That fiscal impact statement has been emailed to you and will be on the website as well. We also have committee members representing our public health and safety partners participating in today's meeting. For our partners, please feel free to utilize this time to complete the health and safety questionnaire. But for now, is there any feedback on the possible fiscal impacts of these changes that committee members would like to tell us about? Gabe?
Hi, Gabe Partonley from Wild. As you can probably guess, I have something to say about the artificially derived cannabinoids piece. We weren't present for the last RAC meeting, and so I figure since this package is still open, I can put my comments in here. Artificially derived cannabinoids, a complete ban on it makes, is a very difficult stance for us to tolerate. The big thing in cannabis for what we have is innovation. This is a new industry. We're a laboratory of innovation. And our processors here in Oregon have been incredible. I don't mean us, I mean the folks that actually make the extracts and actually make the products that allow us to include these, CBN, CBG into our product. They're isolated minor cannabinoids that otherwise naturally occur in the product, and the harm that is sought to be avoided is, these extra byproducts that come in, low quality extracts. Anecdotal evidence, we've had a CBN product on the market nationally for about a year now. It's about 35% of our revenue as a whole in the THC market, and about 25% of our revenue as a whole through our CBD market. It's a very significant hit nationally and locally. The CBG product that we've also debuted is about 10% of our Oregon THC market and about 5% of our wild CBD market that's sold nationally. It makes a lot of sense for us to identify products that cause public safety risks, and it makes a lot of sense for the research to back that up. Through the anecdotal evidence that we've seen, we haven't had any significant complaints or concerns or recalls associated with our products that contain, these CBN or CBG that fall within this really broad definition of what an artificially derived cannabinoid is, and we have the logs to prove it. For us, it's important to maintain the innovation that separates brands from just any regular market. And for us, and for what the OLCC's stated mission is to support businesses, public safety, and community livability through sensible regulation, this type of regulatory creep inhibits the innovation that makes this cannabis industry so unique. So the fiscal impact on us as a business is significant. It's much more significant for the processors that are making the product and selling them nationally. They're selling them across state lines to everywhere but California, because that would be illegal because they don't do hemp in California. And it's with hemp coming online in California, the market's only going to get bigger. I can't even put a number on the estimated fiscal impact for the entire marketplace for the state of Oregon, but it's there. And just because I'm here, the fiscal impact associated with changing the packaging and labeling and the addition of, or the increase of the total package limit for THC is significant. And we would just really hope that the OLCC puts its final rules down on paper before that January 1st, so there's not a significant rush for everybody to get everything in line so that we can get products onto the market. Thank you. Thank you for having this.
Thanks, Gabe. Steve Crowley, just a clarifying question. You mentioned CBG. I know there's a lot of CBG biomass out there. Is the CBG that you're referring to made through artificial means, chemical reactions on extracted material, or is it just simply isolated, extracted from the CBG biomass?
Gabe from Wild. I mean, to the degree that we know, we don't do the actual extraction ourselves. We understand that there is high CBG strains out there that are used to, in this extraction. We are getting verification through our suppliers, and a lot of our suppliers are pushing back and pushing the OLCC to change the way that's worded the artificially derived products. So we're, our knowledge is about a mile deep and about a foot wide, to the extent that we understand edibles really well. And I would recommend that you really work with some of these, folks that process products specifically to ask those questions. But we buy only isolates, 98 to 100% based off of exactly what that product is.
Great. Thank you, Gabe with Wild. The floor is open for any other committee members to tell us about possible fiscal impacts of these changes. Casey?
Casey Houlihan here with the Oregon Retailers of Cannabis Association. I would just like to reiterate a lot of Gabe's points as well. I think that the fiscal impact around particularly the ban on artificially derived cannabinoids as they're defined could be fairly devastating, not just to processors or some producers, as Gabe pointed out, but I think also upstream businesses as well, like retailers, and ultimately consumers will suffer too, because we'll see a lack of diversity of product. I think the one thing that the OLCC has demonstrated a really great capacity for over the course of the last couple of years, and kind of through the vape crisis that we saw a few years ago, is the ability to use science to identify which particular components might be problematic to public health, and then activating their systems to be able to remove those products, isolate them from consumer access immediately, and make sure that they're not getting back into the supply chain thereafter. I think that because we already have such a robust system in place, we should be allowing the science to drive the conversation about what products are or are not allowed, or what additives are or not permitted. And so until we actually do see some significant scientific evidence that a particular component or byproduct of some of these artificially derived cannabinoids could be causing public health concerns, that they should be allowed on the open market as they continue to be presently.
Thank you, Casey. Any other comments from the group? Brent?
Yeah, I would just say real quick, Brent Kenyon, Oregon Original, that we had a lot of luck and really was hoping that the wording would eventually include naturally derived terpenes from fruits, orange oils, and some of these other things that are out there that were actually really interesting for us to add to our products in the beginning. We were sourcing natural terpenes from companies that are fruit companies that use it in foods quite often. And we worked with a food scientist from ASU. He was the head food scientist for years. And really what it came down to with him and the wondering about, he said they had never really experimented with vape products. Obviously in the lab, it was a lot of foods and things around that, but they've done butane and CO2 and every kind of extraction that we do now, they did in the lab for food reasons. And his determination was it really came down to, he explained that terpenes were much like and they're in the turpentine family, so it's a level of what's acceptable for human consumption. And he determined that anything under 6 to 7% was, in their opinion, a safe amount to have in as a fruit terpene or a natural terpene. But a lot of these labs, they can also, the problem is the labs aren't regulated, and that once they make a terpene product, they can create a terpene product and say it's a natural product because they've mocked the actual chemical compound. And so they're even the ones that say that you're getting a product from there that is what it is. It may not actually be derived from a natural source. So it's hard for us to source those things. We love to work with them, and I think it is going to be devastating to a lot of the companies. It's already been fiscally negative on us just trying to figure out this packaging piece that I mentioned earlier. So I would encourage that we continue to have the conversation and work towards allowing some of these safe products into it, and fall back on my comments earlier where what we need to be is transparent with the public, which cigarette companies are not quite often. But if we had a spot where we could go to a website where someone could scan their little bar on the back of the package and go and see all of this stuff. By rule, make it where we have to have it available for the public to choose and let them choose what they're putting in their body. There's many products now that you don't have that option. It's really hard to find out what's in anything. But I think that would be the direction to head. Just let people make the choice and, you know, follow the science where it is. And we really haven't seen a huge negative impact that can be tracked from fruit terpenes being used in an inhalable.
Okay, thank you, Brent. I think I did hear a fiscal impact in there. If there's any other feedback from our public health and safety partners that they would like to share, please feel free, you have the floor. Okay, thank you. If there's any additional information you'd like to contribute, please complete the form we provided and return it to us within the week. Amanda?
Great, thanks. So I just wanted to thank everybody for taking their time today out of their day to discuss this with us. Just a reminder that this is going to be a large package. So we have one more rack coming up that's going to talk about the violation reclassification. And after that rack, we'll have our public hearing and our actual public notice. But any questions or suggestions you have in the meantime, feel free to send them to olcc.rulemaking@oregon.gov. And then also just a reminder that on our website, you can look at the draft language for all the racks and the audios after the racks are done. So thank you. We really do appreciate your time. Have a nice afternoon.
Thanks all.